Hey there, legal visionaries. Welcome to episode 9 of The Global Lawyer, the podcast of the São Paulo Lawyers Institute that brings to you the journeys, insights, and expertise of the finest legal minds shaping the profession in our time. Today, we have an exceptional guest, Professor Michael Granne. He is not only a distinguished legal scholar, but also a dear friend of mine. And by the way, last time we met, he took me to this incredible Italian osteria in Soho, New York. Oh, it was amazing, which just goes to show that his expertise isn't limited to the law. He's also a true buon gustaio with an impeccable taste for the finest gastronomy. And yes, he is a legal powerhouse. He has built this really interesting career in litigation, arbitration, and even academia. His focus on cross-border disputes is what makes his career path so remarkable, as you will see. So, Mike, I'm thrilled to have you here. Also much to talk about. How are you?
I'm well. It's my pleasure to be here, Marina. Thank you for having me.
Okay. Now, your career has spanned litigation, arbitration, academia, and advising on complex cross-border disputes. From clerking at the federal appellate level to now leading your own firm, what key moments shaped your path? And how did they influence the way you approach your practice today?
Some of the key moments predated my clerkship. I spent 2 years in Cabo Verde in the Peace Corps in Cape Verde, and developed an appreciation of different countries and different cultures. And so when I started practicing, I very much wanted to have a cross-border practice that dealt with different peoples and more complicated issues. As when you deal with different legal systems and how they interact, the issues tend to be more complicated, more complex, and as a result, more interesting. And so when I went into law school, I always intended to work in the international arena in some way, whether it be public international law through the UN or the State Department, or more private practice as I ended up after the clerkship. That's where the clerkship or law school and the clerkship really helped me focus, was on that I didn't want to do government work, but rather private practice. After that, when I started at Cleary Gottlieb after my clerkship, I actually started in the transactional group because I didn't know what kind of lawyer I wanted to be. I know I wanted to be cross-border and international, but I didn't know whether I wanted to do deals or litigation or arbitration or some combination thereof. And because I had spent time in Cape Verde, and because I spoke Portuguese, the group there had me doing a lot of work in Brazil on securities transactions, loan documents, things of that nature. That was an inflection point. I didn't find that work particularly interesting personally. No disparagement for those who do practice in that area, but it wasn't for me. And so I transitioned from that into litigation and other dispute resolution practices. So I did some corruption investigations for a while. I did some white collar work, FCPA investigations, and then transitioned more into sort of full-time litigation and arbitration. At that point, my twins were born, 18 years ago now. And I decided I wanted to branch out into academia. So at that point is when I switched to full-time academic life for about 4 or 5 years before coming back to practice. And now I straddle the two. I teach at Seton Hall Law School. I practice at my firm and do a little bit of both. Hopefully not too much of either, but just the right amount.
Okay, just to find the balance. So that's such an inspiring journey. So you have these different fronts to practice, and it's fascinating to hear how you have transitioned so smoothly from one. You took your decisions. You decided to go on and focus on litigation and arbitration, and also academia. And I know you've had the unique experience of representing both foreign sovereigns and multinational corporations in U.S. courts, isn't it? Could you share a particularly challenging or groundbreaking case you've worked on and what it taught you about the intricacies of multi-jurisdictional litigation?
One of the most interesting cases I worked on was while I was at Cleary Gottlieb. We were representing a government, an oil producing government, and the underlying issue was relatively complicated. But what the legal issue came down to for the purposes of this litigation was, since a company in Texas owed the government money, where was that debt? So the debt is obviously, it's just a number on a spreadsheet, but was it within Texas? Was it in Africa? Was it somewhere in between? We had a litigation that spanned several years and many trips from the trial court to the appellate court and back to the trial court about where that debt existed. So which court might have jurisdiction over it, of course. So that was a particularly interesting one. Again, at Cleary, I worked with John Blackman, a partner there with whom I worked a lot. An exceptional lawyer representing the government of Mexico in U.S. federal court on lawsuits about a World War II era worker program, some of the issues that remained on the resolution of that program. And so that was legally not particularly complicated, but politically much more so, because the government of Mexico was very much involved in that. And then I've done any number of just plain corporate commercial litigations across jurisdictions, the most mundane sometimes contract cases, and then sometimes more complicated and confusing facts depending on the circumstance. Often I spend a lot of time explaining the U.S. legal system to
I can imagine
people from around the world, particularly with regards to discovery rules and why you just can't destroy your documents. But it's good fun. And that's where my history in academia helps, because as a result of teaching, I'm far more sensitive, I think, than most to what expectations people may have, even if they're incorrect, as a result of different backgrounds and different socio-legal backgrounds.
Yes. That must be quite something. And also representing sovereigns and multinationals in such high stakes dispute. And the cultural aspects also. And you have
the cultural aspects are really for me, the most interesting part, because you never, until you work with another legal system several times with some detail, you never fully appreciate, well, you'll never get the same sense of it you will of your own legal system, but even to understand where the pitfalls may be and where you may find problems or issues that you don't expect. For a Brazilian example, I understand there's a constitutional right to ex parte communications with a judge. That is anathema for Americans. It is what ex parte communications are almost universally prohibited. They're very restricted. So you can never speak to a judge without the other side being present. Imagine my surprise when I found out that not only can you, but you have a right to do, enshrined in the Brazilian Constitution.
Yes.
And that's one of those things. It's an example where no American would ever expect that to be there. It's just completely counter to our understanding of how the judicial system works. And so being sensitive to those kinds of questions that it might be out there, and learning to ask general questions at the beginning of a relationship or a representation is really crucial.
Yes. And that's like navigating a legal minefield, because you have to be careful and not to abuse or not to misunderstand how you should act professionally.
Yeah. And the minefield, frankly, is a good analogy, because you can't see the mines. You don't know where they are. So you're walking across this
and then you step on it,
and you may step on a mine without ever knowing it was there. So it is, it can be definitely a challenge.
Yeah. And speaking of challenge, you've taught at several prestigious law schools, and you currently teach a wide range of subjects, from civil procedure to international arbitration. How does teaching inform your practice as a litigator? And what key skills or knowledge do you think lawyers need to excel in international law today?
I'll answer the second question first. I think that cultural sensitivity is the key. Obviously, speaking other languages helps. Being able to communicate is crucial, regardless of what language you're in. But It's so
Right.
much better if you can switch languages as need be. But that obviously, unless you started before you became a lawyer, you're likely not going to get the level of fluency you might need to really
Yes.
work in that language. What can you do if you are somewhat further along your career, but not multilingual, perhaps? I think traveling, meeting people, talking to people, trying to learn about people, being interested in people, that goes so far in understanding
Yes.
and learning and appreciating that other legal systems, other ways of doing things are not wrong. And that's the thing I probably learned or helped that academia has helped me develop most is that appreciation for
Uh-huh.
other ways of doing things, particularly in procedural rules. You might argue that a substantive contract rule or tort rule is better or worse, and it's morally, there's some moral imperative why it might be so. That's much less true with procedural rules. And everyone understands what the goal is, a relatively efficient, fair as possible adjudication of a dispute. But how you get to that outcome, there are many ways to get there, and everything involves trade-offs. So trade-offs
Yes.
that the United States has made in terms of pushing for discovery i- in an effort to get to the quote truth by encouraging
Mhm.
the exchange of documents and whatever each side has, but at great cost, right? It can be incredibly expensive. So you have a trade-off there between the search for truth and the expense. So and appreciating that those relationships and how different jurisdictions approach it has been immeasurable in cross-border practice because it helps me explain to Brazilian lawyers, French lawyers, Italian lawyers why we do the things that we do. And also if I can share an anecdote about the
Yes, please.
no,
Uh,
the ex parte
okay.
communications,
Uh,
if a Brazilian lawyer expresses their surprise at our discovery rules, I can turn around and say, it goes the other way too. You do things that we find crazy. And I think that kind of appreciation goes a long way in I won't even say international practice because I'll leave that for my friends at the UN, but in cross-border practice, it's the single most important thing.
the common law system and the civil law systems, they are different, and everyone keeps saying that civil law is based on statutes, common law is not based on statutes, but rather on precedents. But the truth is that the common law system is based on statutes as
Oh, yeah.
well. And precedent is not the first source, isn't it?
No, I think that's true. The dichotomy of common law versus civil law is not quite a yes or no answer. It's more of
Okay.
the high end of the civil law side where every judge gets to reinterpret the statute how they see fit, as opposed to the
This is so
more common
interesting.
law, which is you are bound, once a statute is interpreted, you are
Mhm.
bound to follow the interpretation of the previous court, so long as it's your court or a higher in quote court, a more powerful court. And so it tends to lend itself to a little bit more stability and interpretation. That
Eh,
said, historic,
ah,
many of the rules that are now in statutory form were developed interstitially by judges. So a judge would resolve a dispute between party A and party B. In England,
mm,
this was often in the 17th, 18th centuries,
uh-huh.
and resolve a case in some way because that was the way
Okay.
they thought it should be resolved. And those rules then became to be enforced as law over time. And that's what the common law development of law was.
Everyone say, at least everyone who is not quite familiar with the common law system used to say, okay, in the common law system, we have the only precedents. Of course, we all know that there are statutes, but there's still this belief that precedents overcome statutes, or that the first source would be the precedent.
No, I think it's not that the first source is the precedent, it's that it's the statute might say a park, right? The classic example most law school professors in the US use is no vehicles in the park on weekends. Okay.
Okay.
So if I say no vehicles in the park on weekends, I think everyone would agree that a car in Central Park on Saturday is forbidden. But what about on Christmas Day? It's a holiday, it's not a weekend.
Mm.
What about a bicycle?
Yeah.
What about a
Yeah.
motorcycle?
Yeah.
So
Yes. Yes.
that's where that's where the precedent
Becomes
binding is that
binding.
when a Supreme Court or an appellate court says the statute, when they say vehicle, they mean motorized vehicle.
Yes. Yes. Okay. So
Okay, so
this is
then what about an
the
electric bike?
okay. Yes. And in discovery, I will also say that okay, in arbitration, I think we found a middle ground on that, because when you have a common law client or a question involving civil law and common law parties, you have to reach an agreement and to define the rules. Of course, we have the standard, but how to operate all the discovery thing or the production of proof, the evidence, how the evidence is going to be presented, is something that must be really clearly agreed beforehand.
Yeah, and arbitration, that is one of the real benefits of arbitration for parties who are in cross-border international business, is that it is a middle ground between judicial systems.
I think this is fascinating.
Yeah, many times you have two parties, one from country A and one from country B. The party in country A doesn't want to submit to country B's courts and vice versa. That's where you end up either with a third court or more commonly these days, arbitration.
Yeah, yeah. Now, the first part of the question.
I forgot what that was.
Yeah, but yes, of course, no problem. It was about teaching and teaching you how teaching informs your. I think you have pretty much
I
answered
think I
it. But
answered that a little bit. Yeah,
Yes,
just
you
being
did.
exposed to more. Also, if you can explain some of the legal doctrines to first-year law students, you can explain it to anybody. So, you can explain it to clients. You can then, it gives you, I think, a different way of breaking down issues that can be helpful in practice. It also just gives you an in-depth knowledge base of things that unless you teach them, you don't necessarily come across them in that level of granularity.
Absolutely, absolutely. And because if you think about what teaching requires, it forces you to articulate legal reasoning with clarity, and this also makes you a sharper litigator. And then you have to be able to answer questions, to explain things in a way that connects with different types of learners. And dealing with international law, it's which is constantly changing. It's like a moving target, right?
Yeah, no, it definitely, the skills you need to be an effective teacher, particularly in the US educational system, which is far more interactive than most foreign systems. It requires constantly answering questions, asking the right questions, and trying to develop a rapport as well with your students. And in some ways, it's like taking a deposition, right? You need to, you're seeking information, but you're also trying to establish a rapport so that the deponent, or the student in this case, is comfortable and just starts giving the answers that you want.
Yeah, and on top of that is you have to keep yourself intellectually engaged in a field that is always evolving, and it's like professional development is built into your job, right?
Absolutely. And I just like working with the students. I find that to be the most gratifying part of it, is watching the students, particularly the first year students, learn not even the substance of what I'm teaching, but as we tend to say probably too often, but how to think like a lawyer, how to break down a case and an argument into its constituent pieces and make a strong legal, logical argument, requires training. And unless some people come to it naturally. And if you do, more power to you. That's a wonderful gift. But for most of us, you have to learn how to do it. And teaching that part, I find, actually is in some ways more fun than the substance.
And my next question is along these lines, because someone fluent in multiple languages, coming back to the cultural and language aspect, with a special focus on Brazilian and Italian clients, what unique challenges and opportunities have you encountered when representing clients from these jurisdictions in the US legal system, or where else, anywhere?
Well, we'll say cost. both Brazilian and Italian clients are consistently impressed slash overwhelmed by how expensive litigation in the United States is. I think that's the first barrier. The
Mm.
second barrier is the American rule that the default is you pay your own fees, as opposed to if you win, you get your fees back. I think those
Yes.
are two barriers that are well out of my hands, but I need to tackle every time I deal with a new client. Culturally, this isn't necessarily a problem for me, but something that I either learned or was more amenable to from the beginning. Both Italians and Brazilians, in my opinion, tend to be far more face-to-face, personal relationship-driven cultures than the United States is typically, or than England might be, where it is, I don't want to say more informal, but it's just a different kind of personal relationship. I think
Mhm.
that is, obviously, we're talking in broad stereotypes and generalizations here, but the
No, but
Latin
you're right.
Mediterranean cultures tend to be far more that it's difficult to meet someone remotely in Brazil, if not impossible. You really need to meet in person before any kind of real relationship can develop. And that's, I think, true in Italy as well, and in many parts of the world, not necessarily in the United States.
Yeah, this is a trait of our culture and Latin people. This is something that is embedded in our, it's wired in
Hardwired, hardwired.
hardwired. Yeah, hardwired. And also, in doing that, you have to bridge those entirely different legal systems. And you have to understand how a whole different way of thinking about the law involved in these
Yeah.
cultural aspects.
No, that's exactly right. It less about the specifics of the law and more about the structure and attitude of the legal system. Uh,
Yes.
because in one of the classes I teach on international business transactions, I'm constantly talking to the students about how do you develop a sensitivity for the issues that might arise in another legal system, because we have assumptions. We don't even know they're assumptions.
Yes.
As I said, the ex parte communications if you may remember the Amanda Knox trial, and she was an American who was accused of murder in Italy and was jailed for a while there and
Mhm.
had several different procedures in Italy. Obviously the Italian criminal procedure system is completely different from the
Yes.
American one, and that was incredibly difficult for the average American
To understand.
why it was going that way and why that was fair, that the American system is the only possible way. There are
Yes,
lots of
yes.
other systems that
Yes.
they
So,
do okay.
yeah, and it's about being aware of your own biases, I would say that, and being willing to learn from other perspectives, because there's this dichotomy, because if you are curious about it, you are not judgmental. It's like giving space for new ideas and not trying to predict how things will play out. And so
No,
this
I
is
think
about
that's right.
cultural
I mean,
awareness.
the problem is that it's difficult to know what you don't know. So
Yes, yeah,
you
yeah,
never
definitely. Yeah.
it can be always surprising, and it happens to me still, as I said, with the ex parte communications, that
Yes.
there are just some things which are different everywhere, and you never know what it's going to be and what's going to be a problem.
Mm-hmm.
That's where working with local counsel helps, but also just the more experience you get working with more and more different legal systems, you just learn to ask the questions. What is your expectation? What is your understanding? Think broader
Mm-hmm.
question. If you listen to the answers carefully, sometimes you can pick up on problems before they happen.
Before they actually, yes. And yes, yeah, you can say that cultural factors sometimes can be just as important as the legal arguments themselves.
Absolutely.
You
I
have to
mean, you
be.
have I've been part of arbitrations where the arbitrators were European civil law trained, and some of the counsel were, I will say, stereotypical New York litigators who tend to be
Mhm.
far more aggressive, particularly
Mm.
in cross-examination than
Mm.
a European would ever undertake. And so you could see the panel become alienated by nothing to do with the law, but just
How they behave, how he behaves.
abrasive nature of the cross-examination. And not to say there was no ethical problem, there was nothing, in quotes, wrong with it, but it was a lack of understanding of the legal culture of the tribunal led to a significant problem for that particular counsel.
Yeah, and that perfectly illustrates how cross-border legal work isn't just about the law itself. It's about bridging these legal mindsets. Oh, and now let's shift gears a bit here. As Brazil continues to align more closely with the international legal market, and particularly in arbitration and cross-border transactions, new opportunities are emerging for practitioners across all areas of the law. So based on your experience, what key insights would you share with us or with Brazilian lawyers seeking to steer through global disputes effectively?
Effectively. I think that the Brazilian arbitration community has done a wonderful job of developing itself over the last decades and is far more developed than it was when I started practicing in this area 10, 15, 20 years ago. There was, I won't say none, but a nascent, very beginnings of one in Brazil, and now it's booming. And I think that continuing to develop arbitral institutions, arbitrators, different practitioners who are experienced both in domestic and international arbitration is crucial for international reasons. Obviously, English is the most common language in these arbitrations, particularly in the Americas, when it's parties have a different language. Obviously, it's not by no means is it the only language, but probably the most.
No, but it is the most common.
Yeah, and
no doubt.
And sometimes you'll have disputes where English is not the native language of either party, but it's a compromise because the Brazilian company may not want an arbitration in Italian and the Italian not in Portuguese. So you have English as an alternative that everybody is less uncomfortable with. But so for Brazilian practitioners, obviously fluency, mastery of English is I won't say required, but is certainly recommended for international practice, whether it be American or English, UK English. I won't judge, but the linguistic skill and, as I said, the development of the Brazilian arbitration bar has been incredibly impressive and incredibly rapid over the last decades.
Yes, we are seeing more Brazilian lawyers stepping confidently into global legal roles because of international arbitration these days.
Absolutely. And I think the LLM programs that various law schools in the U.S. have run for any number of years, and Brazilian lawyers who have attended U.S. law schools spent a year, not only to gain some of those bedrock understandings of the American legal system, but just certainly from my own experience, the only way to learn a language is to live in it. And in a way where you can't default back to your own language. It's one thing to say, I'm going to stay in Sao Paulo and practice English every day, but you just don't. Human beings are unfortunately lazy and we default back to our own ease of communication. So living when I was in Cape Verde, no one who
tell us about that.
So I was in the Peace Corps. I was a high school English teacher on the island of Granne in Cabo Verde. And it's a very isolated part of the world. It's a series of 9 islands in the middle of the Atlantic, directly south of the Canaries. If you draw a line from the Azores down to the Canaries and keep going south, you'll hit Cape Verde. It's right in between Africa and Brazil, actually. The line again, those are the 2 lines to connect it. But former Portuguese colony that still speaks a Portuguese more European in style than Brazilian, and also a local language. But I was there for 2 years, and I taught English and coached basketball and and played a lot of cards actually while I was there. But it was a wonderful experience, but also not firmly, let us say, solidified the belief that there's really no way to. At least for me, some people may be able to learn languages in a classroom, but for me, it never worked.
And and folks, he speaks fantastic. Não é mesmo, Mike? Você pode falar pouquinho de português?
Não, se quiserem, eu poderia treinar pouco também, mas.
Tá certo.
O sotaque que faz rir no Brasil.
É muito bom, eu adoro. Okay, so now, moving to lawyers who are interested in transitioning into academia or into teaching while continuing their legal practice. What advice would you offer based on your own experience as a professor and a
Well, I
practitioner?
honestly have no real insight into how it would work in Brazil.
But from a mindset point of view, from a how do you, I know what you mean.
Yeah,
Yes.
I just don't know how the universities in Brazil hire or figure that out. But from a
But from the,
from
from,
a from a practitioner's perspective, just try to teach something you know and love and find interesting, because you're going to
yeah.
be spending a lot of time with it.
Yes, that's important.
Whatever your expertise is, start there. And if you want to branch out into something more esoteric later, it's easier once you a few years under your belt to teach something that is a little more experimental or less central to your career and your practice. So you'll know that way better than anything else. And I have found that students do like hearing war stories, right? So you can
Mm.
always pepper whatever you're teaching with your own experience, and it makes it far more interesting, but also I think it gives the students some context to understand sometimes abstract concepts.
Yes. And I think from the, okay, from the perspective of the teacher, I think it's like a two-way street, because both students and professors, they gain insights. I think it's so refreshing. I think it's really rewarding teaching from a romantic perspective.
No,
I think it
absolutely.
is, because
Teaching
not
is
from a,
I
not
I
from,
love teaching. I don't I tell
yeah,
I teach for free. I get paid
yeah,
because I have to
yeah,
grade. It's only
yeah,
the
because
grading that's
you have to
the
love
problem.
it.
Teaching is a lot of fun, and
Yeah.
I do love that part of it. And you're quite right, it is a reciprocal relationship. The classes where the students are the most interested are obviously the easiest to teach. Develop the students' interests is
Yes. And you also, and if you, when you think about the subject, remarkable how academia allows us to distill and refine some complex aspects of the law and makes us think and reconsider what we believed. I think it's really rewarding.
Oh, I agree. I really I left academia for a few years. My wife's job forced us is too strong, but we ended up moving.
Ah, I
Here
see.
I was on the faculty at a university law school in Pittsburgh,
Uh-huh.
Pennsylvania. And my wife got a job opportunity that we thought was just too good to pass up. So I ended up resigning and moving back. And that's where I went back into private practice about 12 years ago now. And then
Mm-hmm.
taught as an adjunct or taught part time for a couple of years because I still did like teaching very much, or going back to a more full time teaching role in after the pandemic. So last 4 years or so.
Yeah. And you have, okay, your work is in nature. It is a global work. How do you see the evolving role of, now shifting to technology? How do you see the evolving role of technology such as AI and e-discovery tools? Because this is also a very interesting thing mostly in cross-border litigation and arbitration. So are there specific technologies that have been game changers in your practice that you feel that?
Certainly the different technologies available in discovery are constantly changing. We're a small law firm, so we don't tend to deal with massive document heavy litigations very often. But for larger law firms, the ability to use AI or other technological tools to sort and search through vast data sets is incredibly different than it was when I was involved in there, where you could search electronically, but you had to come up with the right word or the right term. Now, through the algorithms and AI, the system can help in a very different way.
Yeah.
In terms of I mean, I'm by far from an expert, but I think there are some very interesting developments in terms of arbitration and how AI and other technologies can be used. Certainly, it has in some ways streamlined the arbitration process, because now there are some remote hearings, although that's up to the panel, and the tribunal or the parties too, may choose for in-person hearings, but some of the more procedural ministerial things do not have to be done in person in a way that they used to because of
Yeah.
conferencing and the like, and just the cultural changes from the pandemic. And I think that's one of the things that has yet to be sorted out in legal practice. Certainly in we were talking about earlier, the cultural differences between Brazil or Latin cultures and the US. I think Americans are far more likely to just jump on a Zoom call or electronically, whereas I still think that Brazilians tend to value an in-person
An in-person
experience
interaction.
more than an American might.
Yes, for sure. And say, yeah, no, I think I was going to go further on technology and on the practice of law, but would you say that, because everyone keeps saying that technology is going to replace us, and how do you see technology? Because for me, particularly, technology, okay, it is a tool, right?
Mhm.
And not a replacement for human judgment. And how do you see it? Do you believe that because we are living this moment, this transforming thing that is happening in all areas, not you take education, medicine, every area, you name it.
Yeah, I think the legal practice is going to change and lawyers are going to have to change. There will not be the luxury of ignoring technology in the way that some lawyers up until now have been able to do. The most effective lawyers will be the ones who are able to use technology for what it's good at and avoid those things that technology does not do incredibly
Yes.
well. I think, I
Mhm.
mean, when saying, you said it perfectly earlier, just saying that judgment, all of these technological products are only as good as the data that they get fed. And so if you have bad data or incomplete data, you get incomplete answers.
Yes. Yes.
Garbage in, garbage out. And so
Yeah. Yeah. Garbage in,
and I
garbage.
think
Yeah.
there
That's it.
are plenty of examples of AI blunders as a result of bad data, and that's always going to be an issue. So
Yeah.
learning to question in a way, and also
How
purpose
to.
of skepticism to just check and recheck
That's
is going
right.
to be necessary. That said, it's going to change, and some of the roles that lawyers, particularly junior lawyers, used to
Hmm.
spend years learning how to do are just not going to be cost effective anymore. It's just too easy, too cheap to
Yes.
do it with technology.
Yeah, that's true. And not to mention that technology should be used to support human intelligence. If we think of e-discovery, AI goes through millions of emails and documents, but it is up to the lawyer to decide or to find out what that all means.
Yeah, and AI can be helpful with that as well. You're still going back to a trade-off between fairness and efficiency. And, you know,
Yes.
you
Yeah.
can come up with any number of very efficient ways. They may not be the fairest, they may not be the most just, they may not be the most accurate. They
Yes.
may be very fast and they may be very cheap. And maybe at some point, those are trade-offs that in some cases people are okay making. But that's less a discussion for individual lawyers and more at the
That,
legislative level.
yes. That's it. Now, so lastly, we're going to the final section of our talk. For Brazilian lawyers aspiring to work internationally, particularly in the US, now, what would you say are the most important aspects of building a career in cross-border litigation and arbitration, of course? And are there any common misconceptions they should avoid? If there were some misconceptions that are not there anymore, and how do you see it?
Language is by far the most important. That's language, fluency, and to the extent possible. And it's a horrible thing to say, but trying to minimize your accent.
Yeah, sound as native as possible.
Yeah, it's unfortunate, but it is just
It's
uh,
something that reaches the inner
yeah. And
senses of people.
yeah, and I think that's one of the. I suppose the other thing is that there are lots of different ways to approach building a practice, and you need to find the one that you are most comfortable doing. Whether that is through working at a large firm or a small firm, or working at a Brazilian outpost of a Brazilian firm in New York or wherever
Yeah,
that might be. Most lawyers, I think, will tell. I will just. I don't need to generalize, but
yeah,
lawyering, getting clients, a networking exercise, and so
yeah,
how you
of
build. But I
course.
don't think of networking as a capital N, but just as how you like meeting people, how you like interacting with people,
Yeah,
and whether that's at conferences or not. I personally don't love conferences, but Some people do. Some people go and they can talk to anybody, and that's who they are. I don't find that I'm particularly comfortable walking up to complete strangers. Other people are, and that's great. But learn what you do and what you do well, and double down on that. Try to develop that part of it, and use that as a key to open up some of the more difficult areas of practice. In terms of the US, obviously, if you want to practice here at any level, an LLM is the minimum requirement. I think many law firms still have a preference for most jobs of JD students. And so that is not an option. Obviously an expensive one because it requires 3 years rather than 1. But it is, if you really want to practice in the United States,
that's the path.
Not just passing the bar, but going through.
Fair enough. Yes, because there is a whole culture, again, the culture and the cultural / professional aspects of the law in the US that are things that people only learn when they go to law school there.
And also many LLMs, for understandable reasons, will take more specific classes. So they'll take, if they've practiced, for example, in international arbitration, they'll take arbitration, and they'll take mediation classes, perhaps, or they'll take international business classes. They won't take contracts. They won't take, but they won't take a lot of the core classes that, even if you never use them in your practice, and God knows you don't often, they do help you learn the legal system and some of the defaults that people assume in the background. And that's really irreplaceable.
Yeah, I agree with you. Yeah. Okay. I have to say, I came into this conversation thinking I already knew the standout moments of your remarkable career, Mike, but I realized that I had only scratched the surface. And your journey is even more extraordinary than I had imagined because of your experience. And unfortunately, we're reaching the end of our exchange. It's incredible how time flies when you're having such a good conversation. But I can't thank you enough, Mike. It's always a privilege to learn from you, and having you here today has been truly special.
Oh, it was my pleasure. Happy to talk whenever you like.
Okay. So guys, before we go, I want to leave you with a thought from Albert Einstein, which says, the only source of knowledge is experience. So let that sink in, and may it inspire you to keep learning, keep questioning and growing, and see you next time. Thank you all. See you. Bye-bye.
Bye-bye.